So friends, in the final stages of Donald Trump's civil fraud trial in New York, Trump goes off on Judge Engoron, the very judge who holds Donald Trump's financial fate in his hands. You know, nobody will ever accuse Donald Trump of being a strategic thinker. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, you may have seen the reporting about how Donald Trump went off on Judge Arthur Engoron, the judge presiding over Donald Trump's fraud trial in New York, during closing arguments. How did we get there where Donald Trump was permitted to speak in closing arguments? Because he was represented by counsel, and ordinarily the rules say that if you're represented by counsel, you are not permitted to speak personally, to cross-examine witnesses, to make closing arguments, because you have opted to be represented by counsel throughout the proceedings. Let's start with how we got there, where Donald Trump was permitted to talk during closing arguments in his civil fraud case, and then let's look at what Donald Trump said. But to talk about how we got there, I want to read the email traffic, some of it, between Judge Engoron and one of Donald Trump's lawyers, Chris Kise. And this email traffic is equal parts amusing and appalling. So let's start with an email from Judge Engoron to Donald Trump's lawyers after they informed the judge that Donald Trump wanted to make part of his own closing argument. This from the judge. In my sole discretion, I will consent to let Mr. Trump make a closing argument if and only if, through counsel by January 9 and by himself personally on the record just before he speaks, he, Trump, agrees to limit his subjects to what is permissible in a counsel's closing argument. That is, commentary on the relevant material facts that are in evidence, and application of the relevant law to those facts. He may not seek to introduce new evidence. He may not testify. He may not comment on irrelevant matters. In particular, and without limitation, he may not deliver a campaign speech. And he may not impugn myself, my staff, plaintiff's staff, or the New York State court system, none of which is relevant to this case, and all of which, except commenting on my staff, can be done and is being done in other forums. If Mr. Trump violates any of these rules, I will not hesitate to cut him off in mid-sentence and admonish him. If he continues to violate the rules, I will end his closing argument and prevent him from making any further statements in the courtroom. If he violates the current gag order against him, I will immediately direct court officers to remove him from the courtroom forthwith and will fine him not less than $50,000. Finally, he must state on the record before he begins to speak that he also understands that, without exception, defendants collectively have only from 10:15 to 12:45 with one 15-minute break to present their arguments, meaning that whatever time he speaks is time that other defense attorneys will not have. And then, friends, this reply from an alleged attorney, Chris Kise. Justice Engoron, this is very unfair, Your Honor. You're not allowing President Trump, who has been wrongfully demeaned and belittled by an out-of-control, politically motivated attorney general, to speak about the things that must be spoken about. I mean, I think a fair question is, did Chris Kise really draft that? or did he just cut and paste it from something Trump drafted and told Kise, this is what I want you to tell Engoron? I think that's a fair question. Well, in response to Chris Kise's email, here's what Judge Engoron said. I won't debate this again. Take it or leave it. Now or never. You have until noon, 7 minutes from now. I will not grant any further extensions. And Attorney Kise did not meet Judge Engoron's deadline, so the judge ruled, albeit in an email, that Trump would not be permitted to make his own closing argument. So what happened? Because as we've already previewed, Donald Trump did talk during the closing arguments in the case. Well, first let's talk about the law and the rules of procedure that ordinarily apply to trials when a defendant wants to start representing himself, in essence, wants to start questioning witnesses or making arguments to the jury. First of all, the law, indeed the Supreme Court has ruled that you have a right to counsel. Indeed, that Sixth Amendment right to counsel is the lifeblood of our constitutional rights. However, you also have an absolute right to represent yourself at trial, as long as, and this is language from the Supreme Court, the judge makes a defendant aware of the pitfalls of self-representation such that he or she, the defendant, makes their decision to represent themselves, makes their decision to waive their right to counsel with their eyes open as to those pitfalls. But just as you have a Sixth Amendment right to counsel, you have an absolute constitutional right to waive your right to counsel and represent yourself. In other words, the government can't force a lawyer on you if you choose to represent yourself. However, the courts have also held consistently that you have no right to what is called hybrid representation. You have absolutely no right to have counsel represent you for some of the aspects of the trial and then to represent yourself in other aspects of the trial. No right to that under the Constitution or otherwise. And Judge Engoron talked about all of these principles in some earlier email traffic, and he noted that under the laws and procedures of New York, Donald Trump doesn't have a right to make his own closing argument to the judge, to the court. However, under the laws and procedures in New York, the judge has discretion to waive that rule that says ordinarily you're not entitled to hybrid representation. You can't have your lawyer do some stuff at trial and then you, the defendant, do other stuff personally. The judge has discretion to waive that. And Judge Engoron, sort of bending over backwards to give some extra rights and opportunities to Donald Trump, decided at the last minute, after being pretty definitive here in this email traffic about how Donald Trump would not be permitted to make his own closing arguments. Well, on the morning of closing arguments, Judge Engoron relented and said, you know what? I'm going to give Donald Trump an opportunity to make a statement to me during closing arguments. And because no good deed goes unpunished, here's what happened. This from NBC News. Headline, Trump rants that New York civil trial is a fraud on me after judge allows him to speak during closing arguments. And that article begins, an angry Donald Trump told the judge presiding over his New York civil fraud trial Thursday that the case is a fraud on me, while lawyers from the state attorney general's office painted the former president as a remorseless fraudster who intentionally lied about his net worth in a successful scheme to line his pockets with even more money. Trump spoke on the final day of his trial. State Judge Arthur Engoron said immediately after closing arguments that He hopes to issue a ruling by the end of the month. Trump wound up directly addressing the judge Thursday after his attorney, Chris Kise, asked whether he could speak for 2 to 3 minutes during closing arguments. No one is more affected in the case than Trump, Kise told Engoron. Engoron had rejected a similar request in an email Wednesday after Kise and Trump didn't agree to refrain from personal attacks in Trump's proposed closing statement. Engoron told Trump on Thursday, after his lawyers had finished their summations, that he could speak for up to 5 minutes, but that he had to focus on the facts of the case. Trump immediately started talking without agreeing. "We have a situation where I'm an innocent man," Trump told Engoron. "They should pay me for what I've gone through. This is not consumer fraud," he added. "This is no fraud. It is a fraud on me." Despite Engoron's warning, Trump wrapped in some insults against him and New York Attorney General Letitia James. Quote, "I know this is boring you. I know you have your own agenda," Trump angrily told Engoron at one point as he spoke while seated at the defense table. He suggested James hates him and doesn't want me to get elected, and he called the case a persecution, leading Engoron to warn Kise to please control your client. So friends, you're probably asking yourselves the question, why, after the judge definitively told Trump's lawyer that no, Trump would not be permitted to speak, to make his own closing argument, why did the judge change course? Why did Judge Engoron change his mind? Here's why. For 30 years, I prosecuted cases in both military and civilian courts, in both federal and local courts, in both trial and appellate courts. And there is this phenomenon that I've seen over and over again, and it is that the judges want to bend over backwards and even bend the rules to let a defendant do something that, strictly speaking, he's not entitled to do. The law may not provide he can do it. The rules may prohibit it. And they do that to try to protect the record on appeal. What do I mean by that? This case will go up on appeal, and the appellate court judges will scrutinize what we call the record of trial, everything that went on in the trial court. And anytime they see a ruling by a judge where the judge kind of bent over backwards to give the defendant the opportunity to say or do something that, strictly speaking, he might not be entitled to say or do, it sort of builds in a little bit of goodwill for the way the judge conducted the trial. And it cuts against a defendant's claim in the context of an appeal. Once the defendant loses the case at trial, it kind of cuts against a defendant's claim that, oh, the judge was horribly biased against me. Well, here's the judge bending the rules, even after you refused to agree to the terms that the judge set for you to give some of your own closing argument. The judge still bent the rules and relented and gave you what you were asking for. And what did you, Donald Trump, do? You abused the privilege by doing exactly what you had been told, what you had been put on notice you were not permitted to do, right? And that's not going to help Donald Trump. It's not going to help Donald Trump with respect to Judge Engoron, who has to decide this case, who really does hold Donald Trump's financial fate, business fate in his hands, not just to the tune of hundreds of millions of dollars that Donald Trump is likely to be ordered to disgorge, to have to pay back all of his ill-gotten gains. But New York Attorney General Letitia James is also seeking a lifetime ban from Donald Trump and some of the officers in the Trump organization, a lifetime ban from doing business in New York. So it's not going to help Donald Trump with respect to Judge Engoron's decision, and it's not going to help Donald Trump on appeal. That when Judge Engoron bent over backwards to give Donald Trump something he wasn't even entitled to. Donald Trump abused that ruling, abused that privilege. That will hurt Donald Trump in the trial court and in the appellate court. And that is a good thing, because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.